We welcome to the program Attorney General Daniel Cameron, who I guess a week from today, your office will be arguing in front of the U.S. Supreme Court as part of the case of Cameron versus EMW Women's Surgical Center. Attorney General Cameron, welcome to the program. I appreciate your time. It's related to House Bill 454. If you could maybe just explain to people what House Bill 454 does and what the argument is.
Well, as always, Larry, thanks for having me on. The case itself that's going to be in front of the Supreme Court originates out of House Bill 454 that was passed in 2018. It's a bipartisan bill that bans live dismemberment abortions. And basically it expresses the compassion and heart of Kentuckians all across our 120 counties to say that if the dilation and evacuation procedure is to occur, again, we don't want it to occur, but if it does occur, we don't want that child in the womb to feel pain. Again, expresses the compassion of Kentuckians all across our 120 counties. This was immediately challenged in 2018. A federal district court said that it could not go into effect. Then it went to the Sixth Circuit Court of Appeals. In the midst of it going to the Court of Appeals, there was a little bit of a musical chairs, if you will, in state government. Mm-hmm. I came into the AG's office, and my predecessor went to the governor's office. So Governor Beshear and myself had a joint agreement where they essentially hired us as the lawyer to defend this law at the Sixth Circuit Court of Appeals. We got an unfavorable ruling at the Sixth Circuit Court of Appeals. At that point, Governor Beshear's team said, we're going to wash our hands of defending this case anymore. I had made it my position known from the very beginning that we will defend the laws of the General Assembly and we'll exhaust all measures to do so. So we, at that point, tried to intervene on behalf of Kentucky to defend the law of the Commonwealth. The Sixth Circuit said no. We didn't want to take no for an answer, so we took that to the United States Supreme Court. And now, on October 12th, next Tuesday, week from today, we'll have an opportunity. My Deputy Solicitor General Matt Kuhn will be arguing in support of our ability to continue our defense of House Bill 454. If we prevail there, we will go back to the Sixth Circuit Court of Appeals, ask for a rehearing on this pro-life measure, and hopefully we will prevail.
Just a couple of things. The House Bill 454, the position you're defending, does it restrict the access to abortion? Is it just on that particular procedure?
It's just on that particular procedure. Again, we don't want the procedure to occur, but if it is to occur, we want it to happen in a humane way. We want to respect life here in Kentucky. That's what this bill has been trying to do. It's unfortunate that it was immediately challenged and that it's been held up in terms of enforcement here in Kentucky. But it is an appropriate measure, again, that expresses the compassion of Kentuckians all across our 120 counties. I'm hopeful that if we win in the United States Supreme Court, my office will continue to be able to defend that law in the Sixth Circuit Court of Appeals, and that we will be able to right the ship and get the law enforced here in Kentucky.
You're being challenged by EMW Women's Surgical Center, I guess, and I'm always curious about this because the argument against, or I guess the argument support, I guess in this particular case, support of this particular procedure. I mean, I think our listeners know where I stand. I mean, I'm not necessarily opposed to abortion at the earliest stages when it's genuinely cells and tissue. I wouldn't want one. I wouldn't want my wife to have one, or my daughter, or my family members to have one. But I'm not going to tell people they can't have it at the earliest stages. But it does surprise me that people have no issue with getting an abortion in this particular way, of dismembering a live unborn child. It strikes me, Attorney General, that's really, it's one of the most ideological divided issues of our time, is because I think we see the arguments in different cases. I mean, I think the right argues that it's protection of the unborn child, and the left argues that it's just a women's health issue. And it's difficult to come to a consensus or a compromise when it's being argued from different perspectives.
You're right. And, my perspective is that I've got to be in the business in the AG's office of protecting our most vulnerable. And that means protecting life. And my wife and I, Mackenzie, are having our first child in January, and this has become keenly more important to me in terms of understanding firsthand, just hearing the heartbeat, as I'm sure many of your listeners have, when their child is kind of at conception, if you will, or right when you have that first ultrasound, being able to hear that heartbeat, then at some point being able to look at a sonogram and see actual images of the baby, that changes a lot of hearts and minds. And I think the more science and technology we have, it actually supports the pro-life movement. Again, in this office, we're going to stand up for life, and I hope that, again, if we prevail in front of the Supreme Court, and the argument's going to be on October 12th, I want to make sure, your listeners get this. That doesn't necessarily mean the court is going to rule that day. It'll be a little bit of a protracted process in terms of when we get a ruling. But as soon as we get a ruling, and if we are victorious, then we're going to be right back in the Sixth Circuit asking for reconsideration of this pro-life measure that, again, had bipartisan support, overwhelmingly expresses the views of Kentuckians to be compassionate when it relates to this particular procedure.
Attorney General, explain to me a little bit about the process. I mean, you're arguing in front of the Supreme Court, and should you get a favorable decision, it gets remanded back to the 6th District. Why is that the case? Well, why would the Supreme Court's decision not supersede or the 6th District's decision?
Well, this is the argument that will be before the United States Supreme Court is our ability to intervene back at the Sixth Circuit Court of Appeals. So we've already asked at the Sixth Circuit for a rehearing. The Sixth Circuit, however, has put a decision on that on hold pending what happens in front of the Supreme Court. So what we have said to the Supreme Court is that we need an opportunity to continue defense of the laws of Kentucky. In fact, the General Assembly, Larry, as you'll know, has empowered this office to be a fail-safe, to defend the laws of Kentucky when no other agency or department will. The AG's office, the responsibility is the AG's office to defend those laws. That's what we're saying to the United States Supreme Court, that they should allow us an opportunity to go back into the Sixth Circuit and argue on the merits of House Bill 454. So what we have in front of the Supreme Court is a question about our ability to argue and defend the law. Once we get a favorable ruling from the Supreme Court, we can then go back to the Sixth Circuit to talk about the substance of House Bill 454, meaning the merits of that particular law, whether it's constitutional or not.
We're talking with Attorney General Daniel Cameron about their argument in supporting of the House Bill 454. It's 454 is Kentucky's law banning live dismemberment abortions. The argument will be on October 12th, a week from today. I've had a couple of people listening to our interview now has emailed me saying, that the Attorney General's job is to uphold the law, not life necessarily. I think they mean is upholding laws, even the ones that you don't like. But in this particular case, you are upholding the law. You are defending the law.
Well, that's exactly right. This, again, was passed in 2018 by the General Assembly. Again, I'll note in a bipartisan fashion. I agree with your listener or the person that emailed that I do have the responsibility to defend the laws that are passed by the General Assembly.
Attorney General, I appreciate your time. Thank you very much. Good talking to you. We'll catch up soon.
Always great to talk to you, Larry. Thank you for having me on.